For judgment item 1 second April 61 of 2017.
On the substantial questions of law are decided against you. This appeal is dismissed. So upload करवा के अभी तुरंत upload हो जाएगा. इसीलिए सारा साइन कर दिया.
Continuing case item 7, first appeal 117 of 2024.
आगे सारे जजमेंट्स आपने लेटेस्ट जजमेंट देखा है सुप्रीम कोर्ट का 2025 दिसंबर यही है कॉम्प्रोमाइज डिग्री पर रजिस्ट्रेशन होगा कि नहीं होगा एडवर्स पोजीशन के क्लेम पर होगा कि नहीं होगा दिस इज डेटेड 20th of December 2024 आधा मिनट भी नहीं लगता है जजमेंट खोजने में क्या करते हैं आप लोग फोन का
इसमें आया
मुकेश वर्सेस स्टेट ऑफ मध्य प्रदेश लाए
उसमें है कि जो पब्लिक प्रॉपर्टी उसके ऊपर अप्लाई नहीं करेगा
कैसे ये जजमेंट से आपने मोहम्मद यूनुस वाले जजमेंट पे रिलाई किया है ना
जी
आप हमको सिर्फ इतना सवाल करते
जी
हैं इट इज नॉट अ सिंपल केस ऑफ एडवर्स पोजीशन
जी
your specific case was that the entire consideration amount was paid
जी
and you entered into the property and then there was a compromise. It is not a case where money did not
given to the vendors
then under such circumstances why it should not be registered.
जी
ये तो हम लोग स्क्रूटनी करेंगे ना
बिल्कुल उसको सबमिशन करना हम लोग कि
और ये जजमेंट आपने देखा नहीं है you need to look at this judgment.
जी हम देख लेते हैं
इसको देख लीजिए भाई ऐसे नहीं करिए क्योंकि ये उसको कंसिडर करके ना मोहम्मद यूनुस वाले जजमेंट को कंसिडर करके ये ऑर्डर हुआ है।
जी
अभी तो इतना हमको टाइम नहीं मिला पूरा पढ़ने का क्योंकि इट वाज अ वेरी शॉर्ट ब्रेक।
जी जी
तो यहाँ पर ये भी डायरेक्टली ऑन द पॉइंट ऑफ एडवर्स पोजीशन है। एडवर्स पोजीशन कपल विद कॉम्प्रोमाइज डिग्री। दो ही चीजें इसमें देखने की जरूरत है कि जो जजमेंट की बात कर रहे हैं उस वक्त अमेंडमेंट 2001 के पहले का है कि 2001 के बाद का है।
वो जो रजिस्ट्रेशन एक्ट
हाँ।
वो जो 1929 का है 1929 का है।
किसका?
जो रजिस्ट्रेशन एक्ट में अमेंडमेंट है वो 1929 का है, प्रीवी काउंसिल का समय का है। एंगेजमेंट प्रीवी काउंसिल से लेके अभी तक चल
नहीं, ये वाला जो 2000 रजिस्ट्रेशन एक्ट में जो सेक्शन
हाँ जो 17 में जो 6 में जो किया गया टू सब 6 में किया गया उसमें देखा जाएगा नीचे वो स्टिक मार्क किया हुआ है। तो प्रीवी काउंसिल को रेफर करते हुए ऑनरेबल कोर्ट ने किया है।
नहीं, हाँ दैट्स राइट। दूसरी चीज ये है कि ग्रेवाल के जजमेंट के पहले का है की बात है। जो यूनिस वाला जजमेंट है उसमें ग्रेवाल के जजमेंट को कंसीडर किया है।
जी किया है
यूनिस वाले जजमेंट।
हाँ तो उसको ये बता देता हूँ। सर्कुलर साइटेशन इसमें किया गया है।
And also you need to address where the parties are exchanging money for land and at the same time they are claiming adverse possession.
जी यहाँ पर एक समस्या है कि जो पैसे का जो ट्रांजैक्शन है डॉक्टर ये 2005 में किया गया एडमिटेड है। मेरा हम सजेशन है कि यदि ये ट्रांजैक्शन कंप्रोमाइज के समय किया गया होगा तो एक शक उत्पन्न कर सकता था कि आप पैसे ले करके और स्टैम्प ड्यूटी बचाने के नियत से आप कंप्रोमाइज में करके ऐसा कर रहे हैं। इस पर एक हम जजमेंट की फैक्ट कर देंगे, फैक्चुअल एस्पेक्ट देंगे।
बात इसको देखिए, अगर मान लीजिए ये कॉम्प्रोमाइज आउट ऑफ कोर्ट
जी
मतलब बिना केस फाइल किए तो क्या कॉन्सिक्वेंस होता है इसका? वेंडर जो है दोनों जने मिलकर सेल डीड बनाते और रजिस्ट्री कर देते, यही होता ना?
नहीं
ये होता कि नहीं होता? मान लीजिए केस नहीं फाइल होता
जो ऐसा नहीं होता इसलिए नहीं होता कि चूंकि लॉ ऑफ एडवर्स पोजीशन में
नहीं एडवर्स पोजीशन की बात ही नहीं कर।
अच्छा मतलब ये कि
हम बोल रहे अगर मान लीजिए दोनों पार्टी हैं
हाँ
और आउटसाइड द कोर्ट वो बोलता है भाई पैसा तो इतना साल हो गया दिए हुए, लेकिन यस आई एम अ जेंटलमैन, आई एक्नॉलेज दैट यू हैव रिसीव्ड दिस मनी, आई एक्नॉलेज दैट यू आर इन पोजीशन, देयरफॉर आई वांट टू एग्जीक्यूट अ फॉर्मल डीड और हम आपको ट्रांसफर कर देंगे। उसके बाद डीड में लिखता कि सारा का सारा कंसिडरेशन अमाउंट हमको ऑलरेडी पे हो चुका है ऑन सच एंड सच डेट एंड देन दे वुड हैव एग्जीक्यूटेड द सेल डीड। देन अंडर सच सर्कमस्टेंसेस जिस दिन रजिस्ट्री होती उस दिन आपको लगता स्टैम्प ड्यूटी।
जी यहीं पर यही तो ट्रैक्स है ये और सब तो सही है। यहाँ पर जिस डेट को हम रजिस्ट्रेशन करा रहे होते मान लीजिए उसका संपत्ति 10 लाख का होता, 10 लाख पर हमको स्टैम्प ड्यूटी लगता। अब यदि किसी अच्छे लॉ लर्नर के पास गए होते दोनों इस पूरे फैक्ट को बताते हुए देखिए ऐसा ऐसा हमारी घटना घटी है तो उसी भी सब्जेक्ट टू कंसीडरेशन क्या कोई भी जो लॉयर है
देखिए हम ऐसे नहीं जा सकते।
नहीं अब एक
you see we will not permit
जी
a device।
हाँ बिल्कुल नहीं
हाँ we will not permit a device।
बिल्कुल लेकिन
you just tell us that why should it be had this compromise जो आज आप कोर्ट के थ्रू आप एक कॉम्प्रोमाइज डिग्री की बात कर रहे हैं, भाई आपस में सुलह हो गया और अब इसको जो है कॉम्प्रोमाइज डिग्री कर दीजिए, ना रजिस्ट्रेशन की जरूरत है ना स्टैम्प ड्यूटी की जरूरत है, वो कुछ करने की जरूरत नहीं है। अब जो प्रॉपर्टी जो है उनके नाम से ट्रांसफर हो गया, बात खत्म हो गई। ठीक है, अगर यही कॉम्प्रोमाइज कोर्ट के थ्रू ना होता, अगर ऑर्डिनरी कोर्स में होता
जी
ठीक है
इस हाइपोथेटिकल में जाते हैं तो निश्चित हम रजिस्ट्रेशन कराते एक एस्पेक्ट होगा। दूसरा एस्पेक्ट ये है रजिस्ट्रेशन नहीं भी कराते और एक डीड बनता केवल इसको मेमोराइज करने के लिए, ये फैक्ट हुआ है।
नहीं होता ना, उससे टाइटल नहीं ट्रांसफर होता।
नहीं, यहाँ पर यही क्रक्स है। हम शायद
उससे टाइटल ट्रांसफर नहीं होता।
नहीं, वो ट्रांसफर की जरूरत ही नहीं है। यहाँ पर हुआ क्या है कि बाय लॉ ऑफ एडवर्स पोजीशन को ठीक से हम लोग देखते हैं तो यदि उस सारे इंग्रेडिएंट यदि हम पूरा करते हैं लॉ ऑफ एडवर्स पोजीशन का, तो एक स्पेसिफिक डेट है जिस डेट से टाइटल डिक्रीज करना शुरू करता है जो रियल ओनर है, और उसका इंक्रीज करना शुरू होता है जो होस्टाइल पोजीशन में गया है, और एक निश्चित डेट को उसका टाइटल समाप्त हो जाता है जो रियल ओनर है। तो जब टाइटल समाप्त हो गया उससे हम डीड क्यों करवाएंगे, उसके बाद टाइटल तो रहा ही नहीं।
देखिए, जब कोई ये बोलकर घुस रहा है कि हम ऑलरेडी इस प्रॉपर्टी के लिए पेमेंट कर चुके हैं, तो वो उसका टाइटल को एक्नॉलेज ऑलरेडी कर रहा है।
जी, वो तो पहला इंग्रेडिएंट है जो उसका टाइटल एक्नॉलेज करेंगे तभी तो हम घुसेंगे। लेकिन सबसे बड़ी बात यह है कि क्या उसने परमिशन दिया था घुसने के लिए? ये परमिसिव पोजीशन रहता है, 100 साल के पोजीशन में है तो टाइटल नहीं बनेगा। स्पेसिफिक केस प्लेंट में कि ये जो पोजीशन है ये होस्टाइल टू ट्रू ओनर है, तो इसलिए वो केस तो है ही नहीं। और जैसे होस्टाइल टू ट्रू ओनर है तो 12 साल क्रॉस करने के पश्चात ऑटोमेटिकली वो टाइटल कंफर्म हो गया। तो जो टाइटल बचा ही नहीं वेंडर के पास में, वो हमको सेलिट करेगा कैसे? नहीं कर सकता। इसलिए उसके बाद उसके रजिस्ट्रेशन का जैसे फिर जो बोले कि मेमोराइज बहुत ज्यादा होता है दोनों के बीच में, तो ये होता है कि मेमोराइज करने के लिए डॉक्यूमेंट बना लो कि भाई इस प्रकार की बातें हो गई। इससे तो कोई डॉक्यूमेंट बन ही नहीं सकता है इसमें। वो जो 2024 वाला कहा गया उसके ऊपर देख लेते हैं। हमको लगता है कि वो भी
इससे कवर्ड है केस।
जी
ठीक है, बस आप ये सारा चीज हमको बताइए।
और दूसरा एक और हम
आई थिंक दिस वन जजमेंट वुड बी सफिशिएंट। बाकी
बाकी तो सभी समझ कर गया होगा, इसलिए इसको देख के कर लेते हैं। और कंप्रोमाइज के ऊपर जो वेगेटेस वाला जो जजमेंट है ना, वो सुप्रीम कोर्ट का जो सब कुछ कवर कर लेते हैं उसमें।
कौन सा?
ये के वेंकटेश का 112(8) में
के वेंकटेश
जी 112(8) में क्लियर कर देते हैं।
कौन सा वाला जजमेंट है के वेंकटेश? अच्छा, ये नंबर 2 1991-3
जी हाँ, जैसे 3 इसका पारा 8 रूल करेंगे देखिए। बाकी की जरूरत तो है नहीं, और ऐसे अपने रिपोर्ट करना है तो वो जो बेस्ट का जजमेंट है उसी से कवर हो जाएगा।
राइट
जी
बताइए।
Council for the alienees has taken the stand that the state alienation are valid and the transferees have become owners of the property and have even maintained that there have been improvements of the property by the alienees. He sought to rely on certain decisions which on being referred to were found to be totally inapplicable to the facts of the case. On the other hand, we find that a similar question arose before the Odisha High Court in the case of Bhajgovinda Mehta versus Janaki Devi, where the power of the court under Order 23 Rule 3 of the Code of CPC, in the face of an objection of one of the parties to the compromise was considered, relying upon several authorities of different high courts, and one of the privy councils referred to in the decision, the High Court held that once the court was satisfied that there was a compromise, it was for the court to record the same, and no option lay before the court to act otherwise. We are in accord with the principle indicated in the said decision and are of the view that as the compromise petition is genuine and lawful, the same has to be acted upon. We direct that the compromise petition shall be accepted, and in terms thereof, the suit shall be disposed of, and the terms of the compromise shall form part of the order to be drawn up in this court for disposing of the special petition. ये compromise पर जो order से clear है, अब कल इसी point पर हमको है कि हम कहीं स्टैम्प ड्यूटी अवॉइड करने के लिए सूट तो नहीं लाए।
And there was a direction कि registrar के यहाँ registry वो उसका terms होगा वैसा, है ना?
ये उसका होगा।
का ये कोई एडवर्स पोजीशन का प्ली नहीं है।
एडवर्स पोजीशन का प्ली में एक है वो
मोहम्मद यूनुस वाला जजमेंट
यूसुफ वाला जजमेंट है उसको लेके
सारे जजमेंट्स नहीं थे इसमें। मोहम्मद यूनुस का जजमेंट
2 मंथ
अच्छा।
यूसुफ वाला में सिर्फ वो दोनों चीज है एडवर्स पोजीशन का भी है और रजिस्ट्रेशन को भी लेकर के है। इसमें एक कॉपी तो नहीं निकाला मैंने इससे पैराग्राफ भी चेंज हो जाता है उसमें यूसुफ के केस में से रिपीटेडली ये बात आई है यदि प्री एग्जिस्टिंग टाइटल है और ये सूट का वो पार्ट है तो रजिस्ट्रेशन कंपल्सरी नहीं है यदि क्योंकि पैराग्राफ के अंदर आएगा हम अभी एसएससी वाला निकलवा नहीं पाए
आपका सबमिशन लिखाते हैं, आप ये वाला जजमेंट पढ़ लेंगे, फाइंडिंग कल लिखेंगे, आपका सारा सबमिशन लिखा देंगे, ठीक है, दैट वुड बी बेटर, क्योंकि एक बार में इतना डिक्टेशन हम अभी दे भी नहीं पाएंगे, क्योंकि आई एम नॉट गॉन थ्रू दोज जजमेंट्स, मतलब जो अभी 2024 का ये जरा उनको बता दीजिए, ठीक है, आप इसको प्रिंट निकालेंगे और ये है इसका दिखा दीजिए। देखिए FA number 117 of 2024. You are the sole defendant.
Yes, sir.
वकालतनामा फाइल किया है.
All the things that are annexing the original documents. Wakalatnama I haven't signed.
You have no objection.
No.
Compromise हुआ था.
Yes,
You have taken instructions on this.
I have taken instructions.
Heard the learned counsels appearing on behalf of the parties. The suit value is 40 lakhs.
आज के दिन को उनका
This appeal has been filed against the judgment dated 24/2/2024, within bracket, decree signed on 1/3/2024, bracket close, passed by Learned Civil Judge, Senior Division First, Civil Court Ranchi, in original suit number 663 of 2023. Whereby the suit has been dismissed. ये क्या है? प्लेंट अंडर सेक्शन 26 सब क्या
जो है
है?
जो सूट फाइल होता है उसको सेक्शन 26 टेम्परेचर फाइल होता है और ऑर्डर 4 के अंदर
अच्छा, तो वो प्रोविजन ऑफ लॉ से
प्रोविजन ऑफ
अदरवाइज इट इज रेगुलर.
या इसलिए
The plaintiff appellant had filed the suit seeking right title interest of the plaintiff over the suit property. The suit property as per the schedule 1 is as follows. Quote करना है. Prayer भी और
सीकिंग के डिक्लेरेशन सीकिंग डिक्लेरेशन
I do not know. जो है आपका
जी
on adjudication, right title and interest of the plaintiff
भी डिक्लेयर
on the suit land be declared.
जी
छूट गया क्या वो? हम लोग तो कोर्ट ही कर देते हैं.
हाँ हाँ कहीं कोर्ट कर लिया
इसीलिए कोर्ट करना जरूरी है.
क्यों सीकिंग लिया गया राइट एंड इंटरेस्ट सीक कर रहे हैं ऐसा लिया है तो उसमें डिक्लेरेशन
Be declared. It was the specific case of the plaintiff that the defendant, through a registered sale deed number 9078 dated 27/1984, brought the suit property from its erstwhile owner and got the name mutated in the rent roll of the state by mutation case number 203 within bracket R bracket close 27/19/1991 by order dated 2/7/1990 of the then Circle Officer Kanke Ranchi. And since then the plaintiff has been and since then they paid rent to the state. Thus, the defendant was the owner of the suit land and was in peaceful possession thereof since 27/1984. The further case of the plaintiff was that in the year 2005, the defendant was in need of money and publicly announced sale of the suit land, in which many intending purchasers contacted the defendant, including the plaintiff, and the plaintiff proved herself to be the highest bidder and negotiated the sale of the suit land, which was finalized with the plaintiff in the year 2005. On 10/5/2005, the plaintiff paid the entire consideration amount of rupees 1,51,000 to the defendant, and upon payment of the entire consideration amount, the defendant assured the plaintiff that she would execute proper conveyance in favor of the plaintiff within a period of fortnight, transferring the suit land in her favor. Despite this, the defendant did not execute the sale deed in favor of the plaintiff, and has been on one pretext or the other. It was further case of the plaintiff that when the defendant did not turn to execute any sale deed in favor of the plaintiff, seeing no way out, the plaintiff forcibly entered into the suit land against the will and permission of the defendant, that is hostile to the true owner, on 23/6/2005, and take forcible possession of the suit land on that day. And since then, plaintiff started to enjoy the suit land as owner thereof, openly known to the world at large and hostile to the true owner, and continued to enjoy the same peacefully till the date of filing of the suit. It was further case of the plaintiff that since 23/6/2005, the plaintiff has been peacefully and as its absolute owner and hostile to the true owner, has been enjoying the property and has also constructed boundary wall and a house. The further case of the plaintiff was that the claim of adverse possession of the plaintiff on the suit land satisfied the basic ingredients, that is NAC VI, NAC CLAM, NAC PRE CARIO during the entire period of 12 years, commencing since 23/6/2005 and culminating on 23/6/2017. That is, up to completing the period of title of the plaintiff by prescription, to which the defendant has acquiesced by not taking any legal action for more than 12 years. अभी एक जजमेंट में होल्ड किया, forcible possession is not hostile possession. अभी की नहीं, I'm just telling you. We will decide, don't worry about it. We will decide this. The further case of the plaintiff was that at the time of the receipt of the entire consideration money for the suit land, the defendant had handed over the original of the registered sale deed dated 27/1984 to the plaintiff with respect to the suit land, Additionally, the defendant had also given to the plaintiff an acknowledgement of receipt of full consideration amount dated 10/5/2005 for the suit land. And the defendant had further delivered to the plaintiff the original of the correction slip showing mutation of the defendant was pertaining to the suit land, as well as the then available government rent receipt of the suit land issued in favor of the defendant. Save and except these documents, the plaintiff had no other document, as the same are in custody of the defendant only. It is further case of the plaintiff that the plaintiff has only de facto possession over the suit land, and therefore the demand thereon in Register 2 of the state of Jharkhand was allowed to be run in the name of the defendant, and de facto possession thereof has been with the plaintiff for last more than 12 years. It was asserted that the plaintiff has absolute title over the suit land with unfettered interest, unimpeachable right, and peaceful possession. A reference was also made to the judgment passed by the Honorable Supreme Court, reported in 2019, bracket close 9, SCC 488. That a civil suit seeking declaration of title on the basis of law of adverse possession can very well be instituted. It has also been asserted in paragraph 16 that on 10/7/2023, it was for the first time the defendant orally claimed the suit land exclusively her own, based on the fact that she had not yet executed any sale deed to that effect in favor of the plaintiff. And consequently, the cause of action arose to file the suit. The suit value, as per the plaintiff, is not less than 40 lakhs rupees. Upon notice, a written statement was filed on behalf of the sole defendant under Order 12, Rule 6 of the CPC. And it was stated therein the case was admitted on 31/7/2023, and the notice was issued to the sole defendant, directing to put up the case on 30/8/2023. On the very first day, that is on 30/8/2023, a joint compromise petition was said to have been filed. And on that day itself, the written statement under Order 12, Rule 6 of CPC was filed, stating as under, quote, that by the benevolent interference of well-wishers of both the parties to the suit, the dispute has wholly been settled outside the court lawfully. 2. The defendant does hereby admit and accept the entire claim of the plaintiff in court. 3. That the defendant has no objection if the suit is decreed in favor of the plaintiff, granting her all the relief sought for in the plaintiff. The order sheet further reveals that the matter was sent for mediation and the order dated 3/10/2023 reveals that the mediation was successful. The joint compromise, ये तो हुआ आपका written statement. Where is the joint compromise petition?
उसे ठीक है।
आपने certified copy फाइल किया है?
जी नहीं उसका फोटो तो भेज दिया।
Certified का फोटो कॉपी?
जी जी ये लेक्चर 3 है
ठीक।
पेज नंबर 88
इसमें जरा देख के बताएंगे जॉइंट कॉम्प्रोमाइज कहाँ पर है? जॉइंट कॉम्प्रोमाइज किस प्रोविजन में फाइल होता है ऑर्डर? कोई बात नहीं, आपने रसीद उसको लगाया है ना?
जी हाँ ये लेक्चर 3 है पेज नंबर 88
The joint compromise petition dated 30/8/2023 has been placed along with the memo of appeal which is photocopy of the certified copy. And same statements have been made in the joint compromise petition as well, as was mentioned in the aforesaid written statement. However, the learned court did not decree the suit in terms of compromise, in spite of the fact that the written statement was filed only under yes. Order 12, Rule 6. And a joint compromise petition was also filed. It was sent for mediation. The joint compromise was confirmed, and confirmation of joint compromise was also recorded in the order sheet. Still, the court proceeded to frame the issues, and following issues were framed. The court thereafter directed the plaintiff to adduce evidence.
यहाँ पर जो इशू फ्रेम किया गया है वो जजमेंट के दिन किया गया है।
जजमेंट के दिन
ये उसमें ऑर्डर शीट में देखा जाएगा।
अच्छा ठीक है, जस्ट इसको ऐसे ठीक है ना, did not decree the suit in terms of compromise, है ना? However, the learned court did not frame any issue, and by order dated 22/11/2023, directed the plaintiff to adduce evidence. And the plaintiff adduced the following evidence.
ये ऑर्डर शीट का 10 अक्टूबर 2023 का ऑर्डर शीट में देख लीजिए। उसमें कोर्ट ने पहले कहा है कि इशू फ्रेम करने की जरूरत नहीं है।
The order dated 10/10/2023 also reveals that the learned court was of the view that the mediation has been successful, and therefore there is no point of framing any issue in the matter. However, pursuant to the direction of the court, the plaintiff examined herself as a sole witness and exhibited the following documents: acknowledgement of receipt of money, Exhibit 1; original registered sale deed number 9078 dated 27/1984, Exhibit 2; original rent receipt, Exhibit 3, 3/A and 3/B; original correction slip showing mutation, case number 203 R27 1991, Exhibit 4. And the defendant also adduced one evidence, that is herself. And defendant during her examination had acknowledged the money receipt, and her signature was marked as Exhibit A. The learned trial court thereafter considered the main issue as to whether the plaintiff has got valid right, title and interest over the suit land. And considered the basic ingredients for declaration of adverse possession. And observe that the plaintiff in paragraph 6 of the plaint has stated that on 23/6/2005, the property came in possession of the plaintiff, and that at present there has been compromise between the parties, and both the parties have given evidence on the basis of compromise. And the defendant has accepted all the averments made by the plaintiff. The learned court thereafter referred to section 101 Evidence Act, 101 of the Evidence Act, and was of the view that the plaintiff has to establish the case on his own. The learned court thereafter observed that even if 23/6/2005 is taken as a date on which the plaintiff came in possession of the property and was in possession of the property since then, and that the original and that the owner did not object to such possession, but the plaintiff had not produced any evidence to that effect. And the learned court was of the view that merely because the defendant has agreed to the statement of the plaintiff through compromise, the same does not establish the case of the plaintiff that he was in possession of the suit property since 23/6/2005. The learned court also considered that the plaintiff had not produced any evidence that the defendant was the owner of the property, and was also of the view that merely because the sale deed merely because the defendant had agreed with respect to the sale deed, on the basis of which it could not be said that the property belonged to the plaintiff and plaintiff was the owner of the property. The learned court also observed that neither the plaintiff nor the defendant could prove the ownership with regard to the property. The learned court also observed that the possession must be continuous and uninterrupted, and the plaintiff did not adduce any evidence that he was in continuous and uninterrupted possession from 23/6/2005, and merely on account of the admission by the defendant, it could not be said that the plaintiff was in possession of the property since 23/6/2005. The plaintiff had also stated that the plaintiff had constructed a house over the property, but no document in support of that, including the tax submitted to municipality or the electricity bill, etc., was not filed. The learned court, after considering the documents and evidences produced on behalf of the parties, was of the view that the decided issue number 4 against the plaintiff, and so far as other issues are concerned, since no opposition was made from the side of the defendant, the same issues were decided in favor of the plaintiff. Yeah. The learned counsel for the appellant.
लास्ट में एक और इंटरेस्टिंग है, वादी का वाद ससंघर्ष खारिज किया जाता है।
The learned court further recorded that the plaint of the
सूट
the suit was dismissed on contest. The learned counsel for the appellant has submitted that the impugned judgment passed by the learned trial court is ex facie not in accordance with the provisions of CPC. He has submitted that once a compromise petition is filed, then under such circumstances the court has no other option but to decree the suit in terms of the compromise. He has also submitted that the compromise between the parties is well established, inasmuch as neither any contesting written statement was filed. Rather, the written statement was filed under Order 12, Rule 6 of CPC, and in the same terms, the joint compromise petition was filed. The matter was sent for mediation, and then after mediation, it came to the court. The court specifically recorded that no issues were required to be framed, and proceeded for and asked the plaintiff to adduce evidence, and ultimately the case was decided on the following issues, or on the aforesaid issues, which were framed only
on the date of judgment.
only while giving the judgment. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 1991 bracket close 3 SCC 338 K Venkateshia versus क्या नाम है इसको देख लेंगे, पैराग्राफ नंबर
8
यहाँ पे SCC से टैली नहीं करेगा. So paragraph number 8, which is quoted as under. The learned counsel has further submitted that since the specific case of the plaintiff, the learned counsel has further submitted that there was no occasion for the court to enter into the legality and validity of the claim of the plaintiff with regard to adverse possession. Once the claim of adverse possession stood admitted by the defendant by way of compromise and also by way of the written statement. The learned counsel has further submitted that the impugned judgment be set aside and the suit be decreed in terms of the compromise. He has further submitted that in case the suit is decreed in terms of compromise, there would be no occasion to get the compromise decree registered under the provisions of Registration Act. He has submitted that once the claim for adverse possession stood admitted by the defendant, then the claim stood crystallized prior to filing of the suit, and the suit was essentially a declaratory suit. And therefore, by virtue of the decree, no title is conferred or decided in favor of the plaintiff. The learned counsel has created in favor of the plaintiff. The learned counsel has relied upon the judgment passed by Honorable Supreme Court in the case of Mohammed Yunus का SCC था ना first one. In the case reported in bracket 2020 bracket close 10 SCC 264, Mohammed Yunus and others versus Rajkumar and others, and he submits that in the said judgment, the earlier judgment of the Honorable Supreme Court in the case of Ravindra Kaur Grewal has also been considered, by which the Honorable Supreme Court held that the plea of adverse possession can also be used as a sword, and it is not only available as a shield. The learned counsel has submitted that in such circumstances, there would be no requirement to get the deed, get the compromise decree registered in the registry office. The learned counsel has further submitted that it is only in case where the compromise decree is used as a device to avoid payment of stamp duty, the decree would still be registered. He has submitted that in the present case, although there has been transaction of money with regard to the suit property, but the possession was claimed by way of adverse possession, and therefore the right stood crystallized in favor of the plaintiff, and such right stood acknowledged and admitted by the defendant in the written statement, in the uncontested written statement, and also by way of joint compromise. That is all. आपको कुछ बोलना है? The learned counsel appearing on behalf of the defendant has submitted that he has taken instructions from his client, and it is not in dispute that the joint compromise petition was filed and the defendant did not contest the suit by filing a formal written statement. He has fully supported the submissions advanced on behalf of the applicant. कल लिखाएंगे थोड़ा देख लेते हैं, आप भी बहुत जजमेंट एक सेकेंड. A judgment passed by the Honorable Supreme Court in the case of Mukesh versus State of Madhya Pradesh, passed in civil appeal number 14804 of 2024, decided on 20th December 2024, has been shown to the learned counsel for the parties, and they submit that they shall examine this judgment, and if there is any distinguishable feature, they shall advance their arguments further to know. इसको देख के आइए,
जी
ठीक है, इसी के बेसिस पे हो जाना चाहिए. लग रहा है फुल्ली कवर्ड है, लेकिन आप देखिए, आप ही के हम अपनी तरफ से लिखा दिए, क्या करेंगे बताइए. देख लिया करिए भाई, आधा मिनट भी नहीं लगता जजमेंट खोजना.
ना इसको नहीं देखना है, इसको मैंने प्रैक्टिस की.
आपको पता होना चाहिए एक सर्च नोट क्या है.
जी हाँ ये
जब हमारे जैसे पुराने जमाने के लोग इतना सर्च कर सकते हैं तो आपको क्या ही परेशानी है.
नहीं मतलब आपको पुराने जमाने के नहीं है.
पुराने जमाने के आप तो हमसे बहुत यंग है, ये सारी चीजें थोड़ा खोजना चाहिए ना. जब जजमेंट हो तो ठीक से हो जाना चाहिए.
हाँ.
क्या आप बोल रहे हैं बहुत सारे ऐसे केसेस हो रहे हैं,
जी 3 केस तो भी हमारे पास ही आया अपनी फाइल में, ये सेम स्थिति है, जो स्थिति इस पे है.
तो एक ही कोर्ट कर रहे हैं कि और भी कोर्ट्स कर रहे
नहीं
हैं. सेम कोर्ट ऐसा कर रहे हैं कि और भी कोर्ट्स कर रहे
अलग कोर्ट से कर रहे हैं. जब श्री श्रीवास्तव ने उन्होंने किया है
हैं. ऐसे नाम लेके नहीं बोल
Sorry. तो अलग अलग मतलब जो 1 है सर्वे 7 है ये 3 इसमें से भी है हमें तो
और दूसरे जुरिस्डिक्शंस में भी हो रहा है कि सिर्फ रांची में?
दूसरे उन्हें कंप्रोमाइज का पता नहीं क्यों इतना मतलब शक की निगाह से उसको तुरंत देखते हैं. वो देखना चाहिए, इसको बुरा नहीं है, लेकिन मतलब जो लॉ है उससे बाहर जाकर के नहीं करना है.
ठीक है, देखते हैं. कल 2:15 बजे कुछ रखेंगे. ओ कल सेकेंड आपने डिग्री कितना मैटर्स है? 27. अरे इतना मेल आप कहाँ रिजेक्ट किए?
25.
कल सेकेंड हाफ में नहीं हो पाएगा. हाँ, कल फर्स्ट हाफ में मैटर्स और फर्स्ट बैच मैटर्स 10:30 बजे करते हैं. हम पढ़ के आएंगे, आप भी पढ़ के आएंगे.
कल
ठीक है, अगर पूरा डिक्टेशन ना भी दे तो कम से कम प्रोनाउंस तो हम कर ही देंगे. ऑपरेटिव पोर्शन तो लिखा ही देंगे, बाकी हम लिखा ही दिए.
ये
मैक्सिमम लिखा ही दिए, ज़्यादा कुछ बचा नहीं लिखा. ठीक है, बस थोड़ा सा वेरीफाई कर लेना है बिकॉज इट मे अफेक्ट मेनी पीपल.
जी
हाँ 10. साढ़े 10 बजे.
Item 4. WPC 4007 of 2020.
Judgment separately have investigation.
आपका नोट किधर है?
इसी में
आपका भी कोई नोट है?
we are very procedural.
And what about other respondents? There is no other respondent.
Still 13 नहीं.
You are supporting? Are you supporting?
No.
तो आपका नोट कहाँ है? आप सपोर्ट करिए, कॉम्प्रोमाइज अभी एक कॉम्प्रोमाइज पे कर रहे थे, हम भी कर रहे
Compromise कर लीजिए.
आपका नोट कहाँ है? हाँ तो मत दीजिए नोट, हम कैसे डिसाइड करें? ये भी अभी नोट दिए हैं भाई, इतना फास्ट हम नहीं पढ़ सकते, उतना कैपेसिटी हमारे में नहीं है.
Capacity बहुत है, समझ लो.
नहीं है, हम लाइन बाय लाइन, वर्ड बाय वर्ड एंड बिटवीन द लाइंस भी पढ़ते
अभी
हैं.
बाहर बोल रहे थे कि अब लगता है कि ठीक ही एज होता था 60, अब थोड़ा सा थकने लगे. भूल करते अभी दिन भर मतलब इशू बहुत छोटा सा है. I'll say what is the issue?
कंटेस्टेड है.
हाँ करते
स्टेक्स भी बहुत हाई।
स्टेक्स है, मतलब ऐसे बहुत सारे मामले आएंगे। This is one
इसीलिए इनको बोल रहे हैं आपको जो स्टैंड लेना है आप अपना रिटन सबमिशन फाइल करिए, हम डिसाइड करेंगे, यू नो सुबह से शाम तक भी सुन के डिसाइड करेंगे, इसको एडजर्न नहीं करेंगे इसलिए। लेकिन इन्होंने नोट दिया है, थोड़ा हम भी पढ़ना चाहते हैं। आप थोड़ा सा हमको 5 मिनट में बता देंगे कोर इशू क्या है,
हम
तो उसके बाद जो है आप भी अपना नोट बना लीजिए। आपको मिल गया नोट इनका,
हम दे दें।
इनको दे दीजिए।
अच्छा।
और आर्गुमेंट के बाद भी अगर मान लीजिए कुछ रिवीजन करना चाहते हैं इसमें कोई वी आर एब्सोल्युटली ओपन टू इट,
अंत तक
बट कंटूर्स को पता होना चाहिए ना। अब बताइए जरा क्या
बस
मैटर
केस
है।
ये है।
पहले इंप्यून ऑर्डर क्या है?
इंप्यून ऑर्डर है मेरा, दो ग्रीवेंस है। एक तो मेरा लीज जो है, जो लैंड हमको अलॉट किया था स्टील अथॉरिटी, तो लीज हैज बीन कैंसिल्ड, माय अलॉटमेंट हैज बीन टर्मिनेटेड एंड इन पब्लिक प्रीमाइसेस एक्ट में मेरे अगेंस्ट में प्रोसीड किए। यही कोर्ट में मैटर। उसके पीछे का फैक्ट्स बहुत सिंपल है, मतलब डिटेल्स हम दिए हैं अपने नोट्स में बहुत
लीज
ज्यादा।
डीड रिकॉर्ड पर है,
हाँ,
लीज डीड में रिन्यूअल क्लॉज है।
रिन्यूअल क्लॉज भी है, परपेचुअल लीज है। मेरा कहना यही है कि परपेचुअल लीज आई वाज अलाउड टू कंस्ट्रक्ट बिल्डिंग एज पर द प्लान which they sanctioned and investments had been made by me. There had been certain restrictions. उसमें बोलते हैं कि भाई it cannot be sublet or the possession cannot be parted with. That is the condition. That is the condition. तो हुआ ये कि हमने रेंट पे दिया था प्रीमाइसेस को। रेंट पे एक कंपनी थी, उसका बाद में चिट फंड का कोई केस में नाम आया सीबीआई में। सीबीआई ने इन्वेस्टिगेशन किया, मेरे ऊपर कोई एलिगेशन वगैरह नहीं, बट सीबीआई ने लिख दिया स्टील अथॉरिटी को कि इनके ऊपर एक्शन लीजिए क्योंकि सबलेट किया। ऑन दैट अकाउंट इटसेल्फ दे हैव कैंसिल्ड माय लीज एंड दे हैव प्रोसीडेड।
नोटिस किया आपको?
No notice. There is no notice. That is additional ground which we have taken. There
But
is
it
no
is an
notice.
admitted fact that there was a tenancy.
Yes. Yes. And हमारा कहना है कि in view of the law of the land, you cannot proceed against me under section 4 of the Public Premises Act. You need, if you want to evict me, you can proceed against me in a civil suit only. बस इतना ही कोई।
क्या है, आप जाके सूट फाइल करिए, रिकवरी कर लीजिए on account of violation of lease.
What my learned senior is saying, first of all, it is not a perpetual lease.
एक
Number
second,
two,
just a moment. It's an agreement. Lease agreement.
Yes.
Now, if your case is that terms and conditions of the lease has been violated,
and therefore it is terminated. The moment it is terminated, section 5.
the termination order is under challenge.
Yes. Yes.
The
Yes.
lease agreement has been terminated.
Yes, the moment and the definition of unauthorized occupant under PP Act includes whose mandate is terminated. The
It has a
definition.
public nuisance.
Yes. Unauthorized occupation 2G. In relation to any public premises means the occupation by any person of the public premises without authority for such occupation means included, and includes the continuation in occupation by any person of the public premises after the authority under which he was allowed to occupy the premises has expired or has been determined by any reason whatsoever. So ऐसा नहीं होगा कि हम अगर पब्लिक क्वार्टर किसी को अलॉट करें या प्रीमाइसेस किसी को अलॉट करें फॉर 30 इयर्स के बाद ही हम उनसे खाली कराएंगे। अगर हम लीज डिटरमाइन करते हैं
Determine पहले हो जाएगा तो
वो अनऑथराइज्ड ऑक्यूपेंट होंगे और अनऑथराइज्ड ऑक्यूपेंट होंगे तो पीपी एक्ट अप्लाई करेगा। इट इज अ सेल्फ सफिशिएंट कोड एंड इफ आई एम proceeding against that they have right to appeal and then appeal before the learned district judge and then before they
the
have
order under PP Act has been
no
crystallized.
it is at the final stage of argument.
It is at the
Proceeding
final
is
stage.
going on and that is not challenged
Final.
before this honorable court and that can't be challenged before this honorable court. The only challenge before this honorable court is that I have passed an order of termination under dictation of the CBI recommendation. This is the only
It
ground.
is information you can get anywhere, from
Yes.
anywhere. Information तो कहीं से आ सकता
And
है
the
इसमें
another
कोई
aspect is whether this landlord tenant dispute can be adjudicated by a writ court. As I will also file my written notes of argument along with those judgments. I am not discharging a statutory duty. The Honorable Supreme Court say, although I am a public authority, my duties are of two kinds. First is of statutory, another is a pure contractual. Merely for a reason I am a government authority or a government company, it doesn't mean that
that all your actions are
all of my
amenable
actions
to
have become
226.
amenable to Article 226. It's not, it cannot be.
You have filed your counter affidavit
I have filed my comment
on these lines.
on these lines. But
So
citations will not.
argument is quite short. So your argument is by way of preliminary objection that this suit is not made, this writ is not made. अभी suit में चल रहा है ना इसलिए suit पे कहानी
First is with respect of
suit के
maintainability.
साथ writ में shift होने में time लगता है.
First is with respect of maintainability.
इसके बारे में आपको क्या बोलना है?
मतलब on two counts. मतलब
You have dealt with
मेरा सिंपल कहना ये है, if they have not raised this kind of objection, first of all, but मतलब even if assume that is a legal ground taken, मतलब the termination of my lease by मतलब Steel Authority of India without issuance of any notice to me, particularly when मतलब in view of the terms and conditions of lease, I have been allowed to make constructions on my own investment.
No, there is no dispute on that.
So
The dispute is only violation of terms and conditions.
violation of terms and conditions, and my contention is that
Where is the order of termination?
connection 30, page 115,
Page 90.
page 115, termination of indenture.
And you just tell us one thing. Are you contesting the PP proceedings?
PPI appeared, there is a stay going
Stay.
on. Stay.
कहाँ से stay है?
Yeah.
कहाँ से stay?
There is no stay as per my instruction.
And they are not proceeding there. This is my instruction.
अरे ये बोलते
Well,
final
the
argument में stay में चल
argument
रहा
में
है.
है.
कैसे
And
बोल-
there
Because
is
my
no-
instructions are otherwise. Anyway,
नहीं आप हमको एक बात बताइए. When you are proceeding under PP Act, your plea that no notice was given prior to termination is available or it is not available?
my contention is that I preferred a repetition, and this is one of the ground I have taken. I have prayed for amendment also in this case, challenging the action taken by them under the Public Premises Act. If Lordship ultimately holds that yes, they can proceed against me under the provisions of Public Premises Act, and the definition will include me also in view of the nature of the terms and conditions of the, yes, of course, I do not succeed. But first of all,
Let us see the termination.
Yes.
Let. बताइए.
Yes. Termination is at page number
अब आप बहस ही कर लीजिए.
95.
You just argue your case.
Yes,
fully.
yes, fully.
हाँ, मैं
छोटा सा तो
ज़्यादा छोटा point है ज़्यादा.
छोटा point.
फाइल इतना मोटा है. बताइए.
Because I am reading it. Annexure 13, 27/10/20. Subject termination of indenture of lease dated so and so in respect of plot number so and so. Please refer to the indenture of lease dated 13/7/2000 and between Shell Bokaro Steel Plants lessor and you, the lessee in respect of plot number GA4 measuring 80.24 square meter in city center, sector 4 BACT. During the course of investigation by CBI, you got that? CBI, Prachi CBI case number RC so and so registered against Messrs. Angel Agritech Limited. It has been revealed that first floor of the building where the lease plot number GA4 in city center was sublet by you. Let's kindly hear. Sublet by you to Messrs. Angel Agritech Limited on 10/8/12 without prior written permission from the lessor. Messrs. Angel Agritech Limited in criminal conspiracy among themselves and others collected money from public at large during the year 2010 to 2013 under various schemes with the false assurance of high and better return. During this period, that is from 10 and 12, branch office of the accused company, Messrs. Angel Agritech Limited was opened in your lease premises at plot number GF4 in violation of clause 6 and 15 of indenture of lease dated 13/7/2000 on your part in respect of the said plot. After completion of investigation by CBI, it has been approved for cancellation of plot number GA4 City Center Sector 4 BSCT allotted in your name where the branch office office of the accused company was operated and crime took place. In view of the above, in pursuance of clause 27B of the said indenture of lease dated 13/7/2000, the undersigned on behalf of said Bokaro Steel Plant notify you that the said indenture of lease dated 13/7/2000 shall stand terminated and the corresponding allotment of land by letter number so and so dated 18/5/2000 shall also stand withdrawn immediately after 90 days from the date of issue of this letter, and you are required to vacate the demised land and deliver its possession immediately to the lesser company, Sale Bokaro Steel Plant, on expiry of the said notice period. You would not be entitled for payment of any compensation by the lesser, irrespective of the fact that the structure, building, etc. is erected on the demised land by the lessee at his cost. You will be free to remove at your own cost any structure, building, etc. built by you within the aforesaid stipulated notice period, failing which the same shall become the absolute property of the lesser company, Sale Bokaro Steel.
Where is clause 27?
Yes, yes. And
Page 30.
Yes,
page,
page 99.
yes. Well, the lease starts at page number 84. Indenture of lease.
84. It's a registered document, unregistered. Admitted document, at least.
Yes.
Admitted है ना?
And
हम first appeal, second appeal में registry खोजते हैं. तो अभी रीट में भी खोज रहे हैं registered है क्या registered.
नहीं, हम लोग को रीट में थोड़ा आदत खराब हुआ है, लेकिन ये होना चाहिए तो इवन रीट मैटर में अगर डॉक्यूमेंट वेरिएंस में हो तो बड़ा दिक्कत है, बट नहीं एडमिटेड है. क्लॉज 27 पेज 98 प्लस ऊपर में जो लिखा है 27 है, शुरू हो रहा है पेज 98 से. जो रेलेवेंट प्रोविजन माइनस कर रहे हैं वो है पेज 99 बॉटम बी 27
Yes.
that if the rent hereby reserved shall be in arrear and remain unpaid for 3 months after the same shall have become due, or if any of the covenants of the lessee's part hereinbefore contained shall not be performed or observed by the lessee, then and in any of such cases the lease shall at the option of the lesser be determined, and the lesser shall thereupon be entitled to enter upon and take possession of the land of the demised land with and including the massage and building erected thereon by the lessee or any part thereof, with rights to the lesser to sue the lessee for recovery of the arrears of rent and or damages for breach of any covenants by the lessee. Upon the lease,
ये नहीं चलेगा. No. नहीं चलेगा. दोनों consequences हैं. termination भी किया है, compensation भी deny किया है. And on the ground that and in the letter itself it is mentioned that you have already decided to terminate the lease. So these grounds are not tenable. Ex parte तो हो ही नहीं सकता है. Did you issue notice to them?
Not
Why not required? Sure, please. बस इतना बहुत है इनके लिए, ज़्यादा टाइम. क्योंकि नेचुरल जस्टिस पर ही चलेगा ये. आप जब इतना एलिगेशन लगाकर, आप जब इतना सीरियस, the more the serious the allegation is, the more onus is on you, right? You have made a very serious allegation. Connivance का allegation लगा दिया. साथ में you have by the approval of the CBI इतना powerful हो गया कि they will ask you to terminate the lease. It is reflecting from this,
yes.
right? So from where do you get this?
Kindly come to an issue.
Conviction हो गया इनका connivance में.
मेरा लेट भी नहीं है, हमारे ऊपर कुछ नहीं.
Let me.
हाँ बताइए.
Alexia, sir.
इतना ही है इनका case.
No notice is required.
From where do you say? No
The
notice.
Honorable Supreme Court says it's a contract. I am the landlord,
You
and
can
I
terminate
merely
without
for the
notice.
reason that I am the public sector entity, I am not bound beyond the law that you must issue notice for terminating a landlord tenant. First Amendment में come.
No, when you make an allegation that there is a violation of terms and conditions of the lease,
Yes.
no notice is required.
Kindly come. Annexure 7, page 62. Let me show those part which are correct. Annexure
Page
7, page 62. It has long become 82.
Indenture of lease.
No, first allotment. Because it is written that
Page number 80.
80, Annexure 7. Because it can be determined that if any of the ground is violated by them, including, let me show my case, Annexure 7, page 62. Allotment of land, the fourth portion, blank space, the ladyship will see, it is for electronic goods. Okay, now kindly come to indenture of lease, Annexure 8.
Where is it mentioned for electronic goods?
Allotment of
Electronic goods.
Yes.
Okay.
So the allotment was made for specific purpose.
Hmm.
Now kindly come to Annexure 8 page is the lease date. Page 82. Clause 6 first. The relevant, because one clause cannot be choose and then it's interpreted in that. What is clause 6? Page 92. And this is a contractual obligation. I am not discharging any public duty. Clause 6. That the lessee will not use the demised land and or the building to be erected as the aforesaid for any purpose other than that for which it has been demised without prior consent in writing of the lessor whose decision will be final and binding on the lessee. So that was the one duty incumbent upon them. I have given for a specific purpose. If they want to use for any other specific purpose, my written consent is required to be obtained. It is nowhere case they ever given any consent seeking application to us. Now kindly come to next clause 15 at page 94.
Yes.
Clause 50, if ladyship will straight away turn to next page because it's
No,
a
you
no.
read.
Okay. That the lessee will use and occupy the demised land and the mahsool and the building erected or to be erected thereon as aforesaid or permit the same to be used or occupied as dwelling house, office, shop or for any other lawful purpose without causing any obstruction, annoyance or nuisance to the lessor or the nearby resident. The lessee shall not make any permanent structure so as to cause any hindrance or obstruction to the public pedestrian. The lessee shall see that public area, pedestrian area, such as verandas, connecting link, pavement, etc., are kept free of any hindrance so as to allow free flow of the pedestrian movement / users, etc., which shall not be obstructed in any way. Now here, the lessee will not assign transfer or sublet. He has subletted, that's a fact. Or underlay or part with the possession of the demised land or the building erected thereon without the prior written consent and permission of the lessor. Notwithstanding the covenants above, if the lessee is unable to run the business, he may inform the lessor for his inability to run the business, and the lessor may, in its sole discretion, either take over the premises for leasing out to a fresh lessee or make such arrangement as the lessor may deem fit and proper on such terms and condition as the lessor may think fit. The lessor will not be called upon to assign any.
Can you read it once again? I lost track. Read this portion once again.
Yes.
The
The lessee will not assign, sublet, transfer, sublet. Subletting was done.
Yes.
Or underlay or part with the possession of the demise. So he has subletted and part with the possession of
That's
the
it.
demise.
Can you continue?
Or the building erected thereon without the prior written consent and permission of the lessor. Notwithstanding the covenant above, if the lessee is unable to run the business, he may inform the lessor of his inability to run the business, and the lessor may, in its sole discretion, either took over the premises for leasing out to a fresh lessee or make such arrangement as the lessor may deem fit and proper on such terms and conditions as the lessor may deem fit. इनसे नहीं चल रहा तो हम किसी और को देंगे या कुछ और प्रोविजन
इन्हीं को भी दे सकते
किन्हीं को भी
पार्ट प्रेमिसेस
यस
दे सकते हैं ना बड़ा अलॉटमेंट है छोटा आप दे दो आप एक तो दुकान चला
वो मेरा डिस्कशन होगा
certainly your
Yes. The lessor will not be called upon to assign any reason for making fresh allotment or such arrangement, and the decision of the lessor in this regard would be final and binding on the lessee. The lessor, now, in the event of breach of on the part of the lessee in observation of the aforesaid covenant, shall have the right to re-entry on the demised land और the building erected thereon. अगर ये वायलेशन करते हैं तो हमको वापस घुसने का री-एंटर करने का अधिकार
re-enter करने के लिए you have instituted that people
Yes, and the judgment cited by them is with respect of a public property जहाँ re-entry के लिए court resort नहीं करके taking advantage of this, I along with my guards enter into premises. Therefore, the Honorable Supreme Court said no. That much.
procedure of law
Yes.
is required to be followed.
Even if a private
So-
or even if a public sector law is there, law has to be
So
followed.
procedure of law is required to be followed.
Yes.
Is natural justice a part of procedure of
The
law?
Honorable Supreme Court says that if I am discharging my judicial, procedural functions, it's a pure administrative or not even administrative.
Just a moment. Natural justice is an integral part of our
Yes.
entire
May
judicial
I
system.
cite specific instance of that judgment?
अच्छा आगे और कोई clause
Yes,
refer करना
है,
चाहे?
है.
अच्छा एक बात बताइए. If you had not assigned any reason, the sole reason was that you have sublet, and it stood an admitted fact, right? तब situation होता है.
Yes.
But the
Kindly.
kind of letter you have issued,
Yes,
unilateral.
it has brought to my knowledge, therefore I have said, and this is,
No, no.
is it a sole ground? Can we see the
That
bottom?
is sole. अगर आपके ऑर्डर में 4 ग्राउंड है और एक भी परवर्स है तो परवर्स है.
No.
You have
The
also
doctrine
said.
of eclipse will apply if my grounds.
लगा दीजिएगा
But that means if kindly come to
इतना
page,
डॉक्ट्रिन ऑफ इक्लिप्स हम नहीं समझे आज.
kindly come to page 95 in view of my termination
Do you?
letter.
We have read it full text.
Yes.
We want to know: is there any other clause you want to rely on the list?
There is another page. Page 97 will be the arbitration clause, and then 99 is another 27.5. 27.3.
तो arbitration भी है. Section 8 में भेज देते चलेगा. अप्लाई कर दीजिए petition section 8.
Arbitration cannot be converted in that
This
is
will not be converted. You are raising an objection that there is an arbitration clause.
arbitration is with respect of quantum. Re-entry, what lady
इसीलिए
has
arbitration
said
clause
कि
का
आप
कारण
cancel
है.
कर दिए.
इसीलिए arbitration clause.
The arbitration is It cannot be with respect of land and tenant dispute, that the Honorable Supreme. But what is for arbitration? If I will take that premises and if the property is erected by you and there is a dispute with respect of valuation of that property, then that matter will go for arbitration.
Okay.
Not the landlord-tenant dispute. The probate, the landlord-tenant dispute, these things are not an arbitrable dispute. Page 99.
Pardon?
Page 99 is the
Read
part
this
what
clause A, pardon. If during the period of the lease,
the demised land is required by the lessor for its own use or for public purpose, the lessor shall be at liberty to take possession. I have not exercised A
that's
as per
right.
my
So,
own
so it
plan.
is not applicable.
I have not exercised A. I have exercised B. That if the rent hereby reserved shall be in area and remain unpaid for 3 months after the same has become due, or here is the additional condition, if any of the covenants of the lease's part herein above contained shall not be performed. Here you cannot sublet, you have subletted, you have violated this, or observed by the lessee, then and in such cases the lessee shall at the option of the lessor be determined and the lessor shall thereupon entitled to enter upon and take possession of the demised land with the including the sewage and the building erected thereon by the lessee or any part thereof with the rights of the lessor to sue, that right is there, for recovery of the arrears of rent and for damages. So he can sue for arrears and damages for breach upon the lessee being determined of the aforesaid residual building erected on the demised land by the lessee with all fixtures and furnitures shall become absolute property of the lessor, and the lessor may allow compensation as its sole discretion. So I have denied, and that's an arbitrable dispute. They can raise, but they can't make an arbitration कि उनको premises से हटाएंगे या नहीं हटाएंगे. Arbitration होगा कि इनका बिल्डिंग का वैल्यूएशन है 1 करोड़, हमने इस तरह से अगर कैंसिल करके ले लिया तो आई विल शो कि आपने उससे ज्यादा डैमेज किया है, therefore I will not give you the price of the land. So they are saying that if I have denied compensation that will give, no, that cannot be. And then kindly see the arbitration clause also, page 97.
आप तो arbitration पे नहीं जाते ना, that provision has not been invoked.
No, arbitration is only with respect of quantum or valuation of that building. If I will say, it's supposed relationship, I will say कि हम 10 लाख ही आपको देंगे, तो उस पोर्शन के लिए arbitration.
आपने तो कह दिया कुछ
हम कुछ नहीं देंगे because तो मेरे पास right है, I will deny, I have denied. Now you raise dispute, I can't deny you for arbitration. Then annexure 13 I will again refer. The bottom
आप
part.
clause C भी तो पढ़िए ना.
Clause?
C.
Yes. The lessor shall be at liberty to terminate the lease at any time giving 3 months notice. That I have given in that. 3 months notice is termination letter itself. The lessor shall be at liberty to terminate the lease at any time by giving 3 months notice in writing to the lessee without assigning any reason. But I have assigned any.
Had you assigned a reason, had you not assigned any reason, they would not have any case.
Yes.
But once you assign a reason,
Yes.
and a serious one like this, they cannot go unheard.
Let me finish, I will come to that. Yes. Therefore, and in case of such termination, the lessee shall be entitled to refund the proportionate part of the premium paid by him, and also for compensation of structure which may be erected on the demised land, and on the basis of capital cost less depreciation. So that is also an arbitrable dispute. Kindly come to annexure 13, page 99. I will read only the next portion. First part is the allegation, the second part. In view of above, the termination letter. First part is the allegation.
Where is, you are reading the allegation, like this termination.
Annexure
letter.
30.
Okay, yes. In view of the above,
In view of the above, and in pursuance of 27 of the said indenture of lease dated 13/7/2000, the undersigned on behalf of State Bokaro Steel notify you that the said indenture of lease shall stand terminated and corresponding allotment of land by letter number such and such dated 18/5/2000 shall also stand withdrawn immediately after 90 days. So 90 days, 3 months time from the date of issue of this letter, and you are hereby required to vacate the demised land and deliver possession immediately to the lesser company Bokaro Steel Plant on expiry of the said notice.
You have referred to clause 6 and 15. Where is clause 15? You have read?
Clause 15 is
Just
Yes.
90.
this is not a science.
So 27B says that for getting a rent as area or any of the clause violated. So any of the clause violated is not referred, but 16 and 15 is violated.
No, it is referred, no. 15 and 6 is referred.
So yes,
Clause 6 and 15.
yes,
Indenture of
yes,
has been violated.
yes. After 90 days from the date of issue of this letter, you are hereby required to vacate the demised land. So 30 days notice was given. I have terminated lease. Now, before termination, am I required to give notice that I am going to terminate? Is any private landlord is required lesser lessee to private companies? Is they are required under the law to give notice to the other side that I am going to terminate? And then is that I have said that I will not give. It's an arbitrable dispute, if you want to say. Now, Annexure 15, page 12 of their supplementary affidavit. After completion of 30 days, 90 days, a notice is given to them on 25/4/2022 that your 90 days has been passed. It is going to the state court under PPI. Why? The unauthorized occupant is defined under the PPI. That you,
ज़्यादा नहीं आप लोग कर रहे हैं.
that is, it may,
इतना उठा पटक सही नहीं है. शोभा नहीं देगा स्टील है. मेरी नजर से. इतना एलिगेशन CBI this that ऐसा करके नहीं करना.
that was even not, I have said this was come to my knowledge. I say 615 violated.
आपके यहाँ कोई सबलेटिंग नहीं हो रहा है, सबको हटा दीजिए.
Is the negative argument is
No,
allowed
not the
for
negative
applicability? It may
It is
be.
not the negative.
It may be, but how? Why? Once it is brought to my knowledge,
अभी तक आग बंद किया. बाकी
it
सब.
may be, but that cannot again
No,
be
that cannot be certain.
again
That
be a
cannot
ground
be
for
easy.
negative equality.
Certainly negative equality के बात.
Yes. And then since second notice, they have reminder they have faulted on 25/4/2022. Annexure 16 of their own writ.
वो तो आपने जब इनिशिएट कर ही दिया है तो वो तो just a formality to throw them out. Because if the lease stands determined.
Yes.
Therefore, they have no other option but to follow it. Unless the determination of lease is itself taken care of.
And
Whether lease has been rightly determined or wrongly determined is not the subject matter under the PP Act. Because the PP Act says that once the lease is determined, then only the PP Act comes into play, not prior to that.
I am afraid, so Honorable Supreme Court in the case of LIC says that if the way it has to be interpreted, that TP Act will not come into play because the special legislation is there by way of TP Act, and therefore being a public authority, I am entitled to resort to the provisions of state officer under TP Act. That is the judgment of, in the case of LIC, TP Act will not come into play because a special category of landlord-tenant dispute is also segregated from a normal tenancy TP Act cases. And that's why the Honorable Supreme Court says so. As the first judgment is 1994, if leadership is behind it. I am passing that judgment also. 1994, vulnerability SCC. I am giving paper, sir.
1994.
Volume 3 SCC, page 552. The relevant is paragraph 22. Paragraph 20. It is also with respect of a contractual matter. We are unable to see any substance in the argument that the termination of agreement without observing the principle of natural justice or the ultra partem is void. The termination is not a quasi-judicial act by any stretch of imagination. Hence, it was not necessary to observe the principles of natural justice. It is not also an executive or administrative act to attract the duty of act fairly. It was, as has been repeatedly urged by Sri Ramaswamy, a matter governed by a contract/agreement between the parties. If the matter is governed by a contract, the writ petition is not maintainable since it was a public law remedy and is not available in a private law field, such as where the matter is governed by a non-statutory contract. Is it a statutory contract? It's a non-statutory contract. Be that it may be in view of in the opinion to the main question. This is the first. The second is 2006, volume 6,
Just a
SCC
moment.
293.
I never read a judgment without its foundation.
Yes.
facts. तो आप जरा इसका foundation
Yes,
fact
I
बताइए उसके बाद।
am sorry for that. I am repeating.
उसके बिना आपको समझ ही नहीं आता।
Yes.
पढ़िए।
Para 2 is there.
Yes.
Devi,
Yes.
Prithviraj some medical college was established by the then government of Jamnagar in the year 1955 for establishing the college. Sri MP Sir donated a sum of rupees 15 lakhs subject to the certain condition. The government hospital, then known as Irvin Hospital, was attached to the said college to meet the requirement of a hospital with necessary bed strength. In the year 1993, the government of Gujarat repudiated one of the conditions attached to the donation, which led the MP Shah Charitable Trust to approach Gujarat High Court for issuance of a writ commanding to the state of Gujarat to continue to abide by the said condition. The writ petition was allowed by the learned single judge, and a latest appeal preferred by state of Gujarat has been dismissed by a division bench. The correctness whereof is under challenge. It's a pure contractual matter. Something was given, withdrawn, that was challenged before the Honorable Supreme Court, despite having lost before the Honorable Single Bench and the Division Bench.
That was a clause by which they could recommend for admission.
Yes, some benefit, but it's a contractual. They have withdrawn. Then the another case is 2006. 2000 volume 6 SCC 293.
2000.
Volume 6 SCC 293. Relevant is paragraph 11.
Just a moment.
Paragraph 11.
Yes.
A statute may expressly or impliedly confer power of a statutory body to enter into contract in order to discharge its functions. Dispute arising out of the terms of such contract or alleged breach have to be settled by the ordinary principles of law of contract. The fact that one of the parties to the agreement is a statutory or public body will not by itself affect the principles to be applied. The dispute about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of the Contract Act. Every act of statutory body need not necessarily invoke an exercise of statutory power. Statutory bodies like private bodies have power to contract or deal with the property. Such activities may not give any issue of public law. In the present case, it has not been shown how the contract is statutory. and this is my first argument, how this contract is statutory. The contract between the parties in the realm of private law, it is not a statutory contract. The dispute relating to interpretation of a terms and condition of such contract could not have been agitated in a petition of under Article 226 of Constitution of India. This matter is for adjudication by a civil court or in arbitration if provided for the contract.
I want to know one thing. Is it a registered document?
This, yes, this is a registered deed.
Seller with all responsibility at the end.
Let me see my doctor. It's registered. It's a registered.
Transfer property and
Because it is registered for 30 years. Wait, I will see this statement. Hey, even if it is registered or not registered, but it's a kind of tenancy. It's a
it is
kind
not
of,
registered, it is month-to-month tenancy. Correct?
if it is not registered, it is not required
It is
always to be
month-to-month
month-to-month tenancy.
What is this?
It is not required.
So I want to know from you, is it registered?
If I will allot land without following the procedure, that will become a matter to be challenged before
We'll
this
see.
court.
But
Because
when
it's-
we are looking into the terms and conditions of lease,
Yes.
and both the parties are looking at the lease. So I will see whether it is registered or not, and whether I can actually look into the terms and conditions of lease.
I think it is registered, but I have to read it first.
Registered.
And TP Act will not apply. Which will say,
After lease about the TP Act will not apply. Big court will decide cases without taking care of TP Act. When you are talking about lease and determination of lease.
yes,
Why?
lease and determination of lease.
Is covered by TP Act. Can any order be passed by the High Court ignoring the TP Act?
The TP Act is not even, my submission is not for with that. I am saying that once the TP Act, Public Premises Act is there, TP Act will become not applicable. May I cite that judgment of the LIC?
Cite it, please.
This 2011-13 SCC 446, Burman Singh and Company versus Life Insurance Corporation. Kindly come first of all paragraph 52. It is
Paragraph
with
52.
50. That in the public premises, how a person become unauthorized, even though initial occupation is authorized. And then how the act will not
Just a
apply.
moment, just a moment. Para number 52.
52. The Public Premises Act creates a forum for eviction of an unauthorized occupant and provides for special procedure for recovery of premises from such occupants. Unauthorized occupation has been defined in a wide manner, the definition PG I have referred, and it includes the continuation in occupation of any person of the public premises after his authority to occupy has expired or has been determined for any reason whatsoever. So he has become unauthorized, and then that will come into play. It would also will include the determination of an authority to occupy whenever the premises are required bona fide or reasonably by the public authority. There was no such special procedure for the public bodies until the Public Premises Act was enacted. When it comes to the requirement of the government or the public corporation, now the public body will take steps under the Public Premises Act. It is, however, relevant to note, as held in the judgment of Jan in case, that the Public Premises Act has a very limited application as against the Rent Act, which
रेंट एक्ट का बात नहीं कर रहे हैं. ट्रांसफर प्रॉपर्टी में there is a provision for determination of lease.
yes,
So this is excluded. We are not talking about rent act. There is a specific provision for how the lease is determined. What is the process of determination of lease? We are not talking about rent act at all. In case of default in payment, there is a special procedure.
or any of the
But it is a case. It is not a case of default in rent. It is a case of
it is also a case of default of rent, but that is not a ground of cancellation.
that is not a ground for
Ground.
cancellation. So forget about it.
Yes.
Right? It is not a case of determination of this realization or default in payment of rent. It is a clear case of termination of lease
Yes.
or determination of lease.
Yes.
Correct?
Yes.
How a lease is to be determined has been given under the Transfer of Property Act. The process for determination of lease has been mentioned. Is government premises excluded?
I think this is dealing with that. I am referring that matter. Application of
Determination of lease, section 111 of the Transfer.
Yes, that is referred. Gives me just.
Okay. Heard the learner transfer appearing on behalf of the applicant. This petition has been filed for the following relief. The learned counsel for the appellant has placed the order of termination of the lease.
दो चीज खाली
अभी अब पूरा नहीं लिखा है 4:30 बजे.
ठीक
Has placed the order of termination of lease as contained in Annexure 13 to the writ petition. The lease is admittedly dated 13/7/2000 with respect to plot number GA4 in City Center, Sector 4, Bokaro Steel City, and the date of termination is 27/10/2020. The lease is between Steel Authority of India Limited, Bokaro Steel Plant, and the petitioner. By referring to the termination order dated 27/10/2020, the learned counsel for the petitioner has submitted that on the face of the document it is apparent that the lease has been terminated on the ground that during the course of investigation by CBI Ranchi, the premises was found to have been sublet and it has been terminated with further allegation that there is criminal conspiracy amongst the petitioner and those persons to whom the premises was sublet. And it has been mentioned therein that there has been violation of clause 6 and 15 of the indenture of lease dated 13/7/2000 on the part of the petitioner. And after completion of investigation by CBI, it has been approved for cancellation of the plot in the name of the petitioner, where the branch office of the petitioner, termed as accused company, where the branch of the office accused company was operating and the crime had taken place. He has further submitted that a reference has been made to clause 27(b) of the lease dated 13/7/2000, notifying that the lease will stand terminated upon expiry of 90 days from the issuance of letter, and the petitioner has been directed to vacate the demised land and deliver its possession immediately to the lesser company on expiry of the notice period. He has also submitted that a decision has also been taken that the petitioner will not be entitled to for payment of any compensation by the lessor, irrespective of the fact that structure, building, etc. is erected on the demised land by the lessee at his cost. And the petitioner has been set free to remove at his own cost the structure, building, etc. built on the premises. The learned counsel for the petitioner has submitted that admittedly serious allegations have been leveled by terminating the lease, and admittedly no notice or prior hearing was granted to the petitioner while passing the order of termination. He has submitted that a serious allegation of connivance of the petitioner with the other persons on the premises have been made. The learned counsel has submitted that on the ground of determination of lease, the respondents have also initiated proceeding under the provisions of Public Premises
Eviction of
Unauthorized Occupant Act 1971, which is pending consideration. The learned counsel, appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that the lease involved in this case is non-statutory in nature, and merely because public authority has entered into lease, the same does not mean that the writ petition would be made.
It's not a statutory.
It is the contract involved in this case is not a statutory contract. However, during the course of hearing, he is unable to say as to whether the lease by itself is a registered document or not. He submits that on the next date, he will inform this court as to whether the lease, long-term lease, which has been annexed along with the writ petition, is a registered document or not, and file an appropriate affidavit to that effect. The learned counsel has also relied upon the judgments passed by Honorable Supreme Court reported in bracket 1994 bracket close 3 SSC 552 para 22 to submit that the principle of natural justice will not be applicable in cases of termination of lease,
Termination of contract.
some termination of contract. He has further relied upon the judgment reported in bracket 2000 bracket 06 SCC 293 para 11 to submit that dispute relating to interpretation of terms and conditions of contract cannot be agitated under writ jurisdiction. He has further referred to judgment reported in bracket 2011 bracket close 13 SCC 446 para 52 to submit that the proceeding has been rightly initiated under the aforesaid Act of 1971 as the same act, the said act provides a special procedure for recovery of premises where the lease has been terminated or determined. The learned counsel has in particular referred to the provision of clause 15,
Clause 6,
clause 6, clause 15
clause 27.
and clause 27B of the deed, of the lease deed, and has also referred to clause 27A to submit that in case of any dispute regarding compensation, the arbitration clause is available. यही आपका? That is all.
Clause 21 is with respect of arbitration at page
27A.
No, 27A is not applicable. I know 27B. Arbitration is clause 21.
21.
At
Okay.
page
21 is that.
At
Sorry,
page
इसको 27A मत लिखिएगा, 27. 21.
This is arbitration.
And I submitted that if the petitioner has any grievance in connection with refusal to grant compensation, he can invoke clause 2.
This is compensation.
It is a tentative order, मतलब से कुछ ऐड करना पड़ेगा।
नहीं अभी कहाँ खत्म हो रहा है, 4:30 बज गया, अभी तो और
हम
सुनेंगे।
सोचे कि आप लिखा दी मेरा सबमिशन तो करेंगे कि नहीं।
नहीं for further hearing, as the court time is over, post this case for further hearing on, आप कब तक affidavit फाइल करोगे? Unregistered document को तो हम देखेंगे भी नहीं और सुनेंगे भी नहीं।
Unregistered document अगर it cannot be seen, then the writ petition is otherwise required to
I
be
don't know
dismissed.
क्या हम करें।
Because that then there is no evidence of reasons.
सब बस तो करिए।
If it is unregistered, then there is no, it's a right encroachment. It will be.
Where I will go, where I will not go, allotment letter also you can see. I am not before a civil court.
10 days time because we have to inform them.
रजिस्ट्री हुआ होगा I'm sure। ऐसा कोई स्टील अथॉरिटी स्टैम्प का चोरी थोड़ी करेगा।
होगा registered.
मेरा क्लाइंट तो करा के है लेकिन।
है ना? कोई बात नहीं है कि एफिडेविट खाली।
2 weeks का yeah.
देखिए रजिस्टर्ड एंड अनरजिस्टर्ड डॉक्यूमेंट का इतना ही फर्क है। टेनेंसी will still exist, but the terms and conditions will not be limited. It will be a month-to-month
And I
tenancy.
am arguing in larger circumference that even those terms and conditions they
ये
are not
unauthorized occupation पढ़ दिए, public premise नहीं पढ़ रहे हैं। Whether it will be treated with public premise, अभी 3 judges bench हम ला के किए।
ठीक है आप लेके आइए।
So मतलब therefore आधा पढ़ करके हाथ मार के बाहर कर दिए सब।
कोई बात नहीं। अभी थोड़ा सुने हैं, आपका अपीयरेंस जस्टिफाइड कर दिए हैं। और आपको क्या चाहिए लगे? बताइए। सुबह से आप बैठे हुए हैं।
आधा गुस्से से
गुस्सा नहीं है तो खुश है कि एक और डेट पड़ा है। सीनियर एडवोकेट है तो क्या परेशान?
after 2 weeks.
ठीक।
ऐसा ही मैटर है ये।
Yes, I agree.
That's right. तो convenient date
छुट्टी के बाद रखेंगे। कल भी छुट्टी के बाद।
इतना हुजूरी पूरा कर देंगे मेरा वो
अच्छा।
पब्लिक प्रोमाइस वाला। ये तो कहिए थी कि फाइनल हो गया है। एज ए लॉस
23 अप्रैल
ठीक ठीक अप्लाई
इन लोगों का ऑर्डर सेंड कर दो
For orders to defect item 10, first appeal 87 of 2016. Along with item
आपका है ये केस मैडम विड्रॉल के लिए आइए FA number 87 of 2016 Counsel for the applicant is present IA number 3117 of 2025 has been filed seeking withdrawal of this appeal. The learned counsel for the applicant has submitted that the appellant be permitted to withdraw this appeal, considering the aforesaid submissions. The present appeal is dismissed as withdrawn. आइए disposed of accordingly. पैसा दे दिए क्या सर? ये भी वही
इसमें IA नंबर 3116.
इसमें भी सेम ऑर्डर है IA number 3116 दो IA क्या किसके लिए
Invitation के लिए और इसके लिए.
पहले से चला बाकी IA क्लोज
Item 13, first appeal 167 of 2024.
Yes ma'am
Lordship needed 3 weeks time to remove the defect. To file fresh ID.
You need time FA number 167 of 22 Counsel for the appellant seeks adjournment 3 weeks आपको क्यों चाहिए
Now to fresh file to fresh ID.
fresh
Yes.
ID
Yeah, there's 2 IA, there's defect in 2 IA. IA number 1225 and IA number.
you want to not press it press करना है कि नहीं करना है
Yes, please.
आपको नहीं पता है
एक ये we have filed by inadvertently it has been filed.
बताइए कौन सा आई
That idea is for amendment of
1225.
12. We'll have to file it afresh. There are some errors in it.
amendment of cost title the counsel for the appellant has submitted that IA number 12 of 2025 has been filed seeking amendment of cost title
But there are some errors.
but
therefore
certain
we-
errors have crept in filing the IA and therefore they do not want to press the interlocutory application with the liberty to file a fresh one. Considering the aforesaid submission, IA number 12 of 2025 is dismissed as not pressed. Liberty is reserved with the appellant to take steps as may be permissible under law. हम नहीं जानते इस दूसरा का क्या है।
both IAs there are some errors. Both IAs.
दोनों
The
में
other
है।
IA number 1525.
15 और 25 ठीक है दोनों का सेम ऑर्डर और क्या करना है आपको एडजर्नमेंट
Yes.
बाकी डिफेक्ट क्या हुआ हो गया
बाकी
एडमिट हो गया
नहीं
डिफेक्टिव है
we still defective. We'll remove it within
counsel for the appellant prays for time to remove
3 weeks.
prays for 3 weeks time to remove the surviving defects प्रेमटी नहीं करना है पता नहीं क्या आपको आईए फाइल करना है goes on 8th of May
Yes.
For orders item 14, second appeal 609 of 2017.
आपका लिटिगेंट नॉन सीरियस लग रहा है इसलिए ये करना है यस ये क्या चीज़ के लिए है वो जो फर्स्ट अपील थी जो है एडमिट करने के लिए उसको निकालिए जस्ट अ मोमेंट प्लीज गिव मी 2 मिनट्स
For admission item 27, WPS 47.
फॉर्मल एडमिशन है 3 फर्स्ट अपील का इसको करना
first appeal. Item 28, first appeal 43 of 2025.
Admit. Issue notice to the respondents for which requisites under speed post along with AD be filed before this court within a period of 15 days. Office to track speed post delivery. AD मत करिए, speed post के साथ AD जाता है क्या? नहीं होता ना? Speed post. Speed post as well as registered covered with AD. सर वेस्ट बंगाल की पार्टी हमको ऑर्डनरी प्रोसेस नहीं कर पाएंगे. इसमें post on 10th of June awaiting service. Call for it. दूसरा
Item 29, first appeal 44 of 2025.
Admit. Issue notice to the respondent under registered cover as well as through speed post. Respondents एक ही respondent for which requisites be filed within 15 days. Call for LCR or same date time.
Item 30, first appeal 55 of 2025.
Are you there? कोई बात नहीं, फॉर्मल एडमिशन के लिए आया फर्स्ट अपील. सेम ऑर्डर कर दीजिए एंड नोटिस जाएगा टू ऑल द रिस्पॉन्डेंट्स, प्रोफॉर्मा भी और सबको भी. ठीक है, रिकॉर्ड कॉल फॉर हाँ 2 week to file requisite under speed post. एक सेकंड, सब तो सेम के स्पीड पोस्ट एंड ऑर्डनरी प्रोसेस. रिक्विजिट फाइल कर दीजिए. स्पीड ऑफिस टू ट्रैक स्पीड पोस्ट
Orders. Orders item 14, second appeal C09 of 2017.
क्या बोलना है आपको? आप इसमें
Yes, my lord, order number 9 dated 25/2/2025. इसमें रेस्पोंडेंट नंबर 10 19 और 27 हुए रिपोर्टेड डेट था my lord, और इसके लिए हम लोग 2 आईए फाइल किए हैं.
तीनों के लिए?
हाँ.
3 आदमी के लिए 2 आइए कि 3 आइए?
नहीं, आईए 2 है. आईए नंबर 23459/25 और एक आईए 3457 है जो सेपरेट लिमिटेशन पिटीशन है फॉर द रेस्पोंडेंट नंबर 27.
कब किसका डेथ हुआ? ड्यूरिंग द पेंडेंसी डेथ हुआ है कि क्या हुआ?
During the pendency, respondent number 27, Savitri Mishra alias Savita Mishra, wife of Madan Mishra, who died on 27th of July 2021.
सबका ड्यूरिंग द पेंडेंसी हुआ है?
यस सबका नहीं, उसके बाद रेस्पोंडेंट नंबर 10 फुलिया देवी who is reported dead at date not known to the petitioner whose
लीगल ईयर्स का नाम का है.
legal here namely जनार्दन मिश्रा alias भज्जू मिश्रा, वीरेंद्र मिश्रा, रविंद्रनाथ मिश्रा.
कौन सा पैराग्राफ में है? पैरा 11.
पारा 11 रेस्पोंडेंट नंबर 27 के लिए.
ठीक है. और पैरा 12 रेस्पोंड नंबर 10 के लिए है.
और 9 है
पारा 9 है लो.
पैरा 9 है.
हाँ
रेस्पोंडेंट नंबर अच्छा
10
10. इनके लीगल ईयर्स आर ऑलरेडी ऑन
ऑलरेडी
रिकॉर्ड.
ऑन रिकॉर्ड
हाँ.
मतलब रेस्पोंडेंट नंबर 11
आपको कुछ बोलना है?
लॉट एक
कौन अपियर कर रहे हैं?
मतलब I appear on behalf of respondent 22, 24, 25 and 36.
11 to 14 अपियर कर रहे हैं आप?
अब तो कर रहे हैं
हाँ कर रहे हैं. लॉट रेस्पोंडेंट नंबर 19 जो रिपोर्टेड था डेड के लिए, लेकिन रेस्पोंडेंट नंबर 9 लाइव है और उसके लिए हम लोगों ने पारा 10 Respondent number 19 Santi Devi, widow of Ashok Mishra. On inquiry, it has been
इसको
found
नोटिस
that
करिए
she is
दोबारा.
alive. Yes, Lord.
Counsel for the appellant submits that in interlocutory application number 3459 of 2025, it has been stated that respondent number 9 Shanti Devi, widow of Ashok Mishra, is still alive. And
Respondent number 19.
she was wrongly reported dead.
Yes.
कहाँ के रहने वाले? कहाँ के रहने वाले?
मोटी.
ये क्या है? POPS Kutti and District Ranchi.
अब मोटी है ना मोटी.
Let notice be issued upon respondent number 19, for which requisite under ordinary process be filed within a period of 1 week. It has been submitted by the learned counsel for the petitioner that the district would be Kutti. आप इसमें काट के सब जगह रांची रांची कर दिए, गिरिडीह को भी रांची बना दिए हैं.
वो पहले हो गया था गलती से.
कैसे हो जाएगा? ये गलती कैसे हो सकता है? गिरिडीह रांची में आ जाएगा. आप एक हफ्ता में रिक्विजिट फाइल करिए, इसके बाद ही ऑर्डर करेंगे. रिस्पॉन्ड नंबर 19 को आने दीजिए. पोस्ट और कौन सा डेट है? अभी सारा केस में डेट डाल देते हैं. 10 जून. रिस्पॉन्ड नंबर 19 को आने दीजिए. चिंता है डेट हो गया, ये इम्पोर्टेंट चीज़ है ना. ऐसे कैसे क्या ही सब्स्टिट्यूट नहीं करते हैं.
लॉर्ड इसमें एक आईए भी है और एक और आई है 3 4 5
ये अपील कब का है?
17.
हाँ, अभी तक तो कोई एजेंसी नहीं, इसीलिए आईए का कोई एजेंसी नहीं.
Item 15 second bill 131 of
सोते
the
रहिए और
committee.
सब्स्टिट्यूशन फाइल करते रहिए. यही है यहाँ पर सिविल लिटिगेशन का कहानी. हाँ बताइए.
This your lordship was taken up last week. Your lordship had allowed my
आइए, वो ऑर्डर नहीं हुआ.
application. नहीं allow करके आज hearing में आना चाहिए था.
अच्छा,
But
wrongly
it has
listed.
been wrongly placed.
हो
on it.
सकता है शायद ऑर्डर नहीं अपलोड हुआ. इसीलिए.
Because the additional questions of law were.
Yes,
framed by
yes,
your
we
lordship.
have already framed it.
So my only prayer would be maybe fixed for hearing any
आप
day.
हैं किसकी तरफ से?
Respondents.
All the respondents.
And my notes are also ready.
दे दीजिए. आप भी नोट्स उनको भी दीजिए. ऐसे नंबर 131 ऑफ 2018. ये तो हम लोगों ने तो अपलोडेड ऑर्डर है. 2 अप्रैल फॉर अंडर एप्रोप्रिएट हेडिंग. तो ये ऑर्डर्स में कैसे है? तो अपलोडेड ऑर्डर. Counsel for the parties are present. Counsel for the appellant has submitted that this matter has been wrongly listed as the Office is directed to check and place this case under appropriate heading on next Wednesday. In the supplementary cost list. तो अब पता लग जाएगा कि कहाँ जाएगा और कहाँ नहीं जाएगा.
ठीक
ठीक है.
It is ready, your lordship.
जो केस रेडी हो जा रहे हैं, हम चाहते हैं लोगों के मरने के पहले डिसाइड हो जाए. और जिसमें लोग मर चुके हैं, उसमें हम ज्यादा दिमाग नहीं लगाएंगे.
ये तो because this was my prayer also because he was already more than 70 years. So he's an old man. I'll pray that your lordship may hear him.
जिंदा लोगों को जिंदा रहते मरने नहीं देंगे.
Item 16, second appeal
इसीलिए
without date
रिकॉर्ड
of authority.
तुरंत मंगा के डिसाइड करा.
ठीक.
अब बताइए कौन
My
केस है?
notice was issued on IA. It has been validly served. The service report is that they have refused to accept the notice. So I will pray that IA may be allowed.
आइए क्या था?
For substitution of respondent 60. 668 of 25.
Okay. Essay number 338 of 2018. As per the office note, the proposed respondent number 16.1 to 16.4 have refused to accept the notice, and the notice has been hung on the main door in presence of witnesses. Today is the first date of listing after notice. Let this matter be posted after 2 weeks. एक तो डेट दीजिए. एक डेट appearance के लिए ना. On 16th of April, awaiting appearance. Notice is accepted as validly served.
Item 17, second appeal 4 of 2019.
Who is there? चलिए जिसमें कोई appear नहीं हो रहा है उसको ऐसे ही करें. Not taken up with time.
Item 18, second appeal 132 of 2020.
Yes.
I have appeared on behalf of the respondent number 1.
There has been some bereavement in the family of Mr. Rohitas.
May be taken up.
इसको ना 2 हफ्ता बाद इसको
16.
post on 16. कोई appearance.
Item 19, second appeal 209 of 2020.
Sole respondent.
Yes, sir. Yes, right. And another I is for setting
Notice
aside.
has been issued.
No, no, sir. I filed another I for setting aside amendment and for that for customer delay.
Substitution. Sole respondent.
Yes, sir.
When did he die?
Died in April 2021.
देखिए IA number 10250 of 24 and IA number 3411 of 2025. In essay number 209 of 2020, the learned counsel for the appellant has submitted that sole respondent has expired. In the year on 29th of April 2021, the details of legal years and successors has been mentioned in paragraph 3 of the interlocutory application. And another interlocutory application has been filed seeking confirmation of delay and setting aside abatement. Issue notice to the proposed legal years and successors of respondent or sole respondent whose details have been mentioned in paragraph 3 of IA number 10250 of 2024 in both the interlocutory applications for which requisite under ordinary process be filed within a period of 15 days from today. और 10th June दे रहे ना appearance का. Post this case on 10th June.
Item 20, second appeal 221 of 2020.
This is under post procedure directed to be issued by order dated 24th January.
On substitution.
Yes, on the,
Second appeal has been admitted.
yes.
आपका एडमिशन अच्छा ये अब क्या है नोटिस सर्व नहीं हुआ रिकॉर्ड आ गया improper deposit of notice upon respond number 13 and 14 has been filed instead of B2 गलत फॉर्म में फाइल हो गया
देख रहे हैं लिखा हुआ है स्टेप्स लेके then press notice
essay number 221 of 2020 as per the office note the notice upon respond number 13 and 14 has not been filed in proper format and therefore it should not be issued. Counsel for the appellant is directed to take fresh steps with respect to notice upon respond number 13 and 14 in terms of order dated 20th of February 2025. एक हफ्ता में ले लीजिए ठीक है
जी
एक आपका रिस्पॉन्ड नंबर 10 नहीं आ फाइल किया सब्स्टिट्यूशन पिटीशन रिस्पॉन्ड नंबर 10 इज रिपोर्टेड डेड जिसका सब्स्टिट्यूशन नहीं फाइल किया पोस्ट ऑन 10th June.
Item 21, second appeal 101 of 2021.
Yes.
Last revision when the case was called, we were granted time to file a substitution IE for substitution.
Not filed.
Not filed.
यहाँ देखिए मेरे ऑर्डर जब हम एडमिट करते हैं ना तो आधा अपील हम डिसाइड कर देते हैं मन में तो प्राइमरी फेसी एक आइडिया बन जाता है अब आप यहाँ पर एडमिट कराने के बाद इधर उधर चक्कर मत काटना ठीक है कितना टाइम चाहिए आपको
4 weeks.
बहुत अच्छी बात है
Address confirm नहीं हो पा रहा है.
Essay number 101 of 2021. Counsel for the appellant seeks adjournment. Post on 10th of June.
Item 22, second appeal 82 of 2022.
हाँ बताइए आप हैं
So there is an IFC prosecution of appellant number 1. Appellant number died on 12th August 2022.
12th August
12th August 2022.
तो आपका आईए इतना लेट से क्यों फाइल हाँ डिले है ना आपका तो इसके साथ क्या पिटीशन फाइल की है सेकेंड अपील कब का है
22 Calendars.
और कब डेट हुआ है 22/4
12th August 22. 12th August 22.
22/4 अच्छा जी कब डेट हुआ है 12/8
12/8/2022.
लिखिए ऐसे नंबर 82 ऑफ 2022 इसमें कुछ नहीं फाइल करेंगे ये तो आपका इतना डिले है कोई पिटीशन फॉर कॉन्डोनेशन ऑफ डिले नहीं है कुछ नहीं अपीलान नंबर 1 इनका वकालतनामा कहाँ है इनका आप सब्स्टिट्यूशन करवा रहे हैं सबका फाइल किया हुआ है देखिए आईए नंबर 1856 of 2025 has been filed seeking substitution of appealant number 1 who is said to have expired on 12/8/2022, the names of legal heirs and successors has been mentioned in paragraph 3 of the interlocutory application, and Wakalatnama on their behalf has also been annexed along with the interlocutory application. तो आप इसमें सेटिंग असाइड अबेटमेंट और वो सब नहीं फाइल करेंगे? नहीं, लिमिटेशन कब फाइल करेंगे? बताइए, नहीं फाइल किए हैं उसमें, पता कर लीजिए अपने सीनियर लोग से। हम नोटिस कर देते हैं, इस बीच फाइल कर देंगे। That notice we issued to the respondents in the interlocutory application seeking substitution. For which requisites we filed within a period of 2 weeks from today, post on 10th of June. जो भी हो आप अपना फाइल कर दीजिए, नोटिस कर देते हैं, जैसे कि देते हैं।
Item 23, CMP 1078 of 2022.
Last day, the service report was not noted on my and so it was posted for the day.
अच्छा, limitation petition for condonation of delay, substitution petition being number. Number 28 has expired.
Yes, and the notices were served for the proposed legal heir.
अच्छा, has been served.
No, my lord. The service report is there, my lord. Dileshwar Saw, who is at the third number, my lord, he has received. So far as others, my lord, he is stating some have shifted to Ranchi and some have living in Barkagaon, Paki. This is the problem, my lord. Exactly, we don't know the address.
ये तो आपको किसके ऊपर नोटिस सर्व करवाना है?
My lord may come to the substitution petition, my lord. At
Returned unserved. ठीक है? CMP number 1078 of 2023. As per the office note, the ठीक है, दोनों कॉन्फ्लिक्टिंग नहीं, एक होते हैं कि ऐसे डू नॉट लिव एट द एड्रेस मेंशन इन द नोटिस।
फ्रेश ऑफिस नोट मिला ना उसको।
अच्छा, ये आया है?
नहीं आया, उसके बाद दिया नहीं
आया ही नहीं।
लास्ट ऑर्डर के पास 29 लास्ट ऑर्डर उसका सबसे फर्स्ट पेज।
So far I have gone to the records. Service report is there, but it was not there in the.
तो इसका ऑफिस नोट आया है?
नहीं आना
इसका ऑफिस नोट नहीं आया है, फ्रेश ऑफिस नोट। आपको इतना देर तक बैठना पड़ा इसका। नेक्स्ट वीक करना, इसका ऑर्डर निकालिए। इसको हम नॉट टेकन अप कर देते हैं। आ जाएगा ना ऑफिस में?
May I just next week, my lord, 7, 8, 9 I am out of station.
कोई भी एक डेट दे दें, कोई भी एक डेट को ना नॉट टेकन अप में डाल दीजिए और ऑफिस नोट बनवा दीजिए इसका।
15-16
आपका आ जाएगा नॉट टेकन अप। आपका 15-16 में आ जाएगा, ऑफिस नोट फ्रेश आ जाने दीजिए, क्योंकि ऐसे पता नहीं चलता किसको नोटिस सर्व हुआ है। हो गया सब ऑर्डर्स खत्म, की बाकी है।
Item 24, first April 8 of 2023.
बताइए। Substituted service of notice. SC.
That has already come.
Appeal is admitted. ये orders में क्यों आ गया? आइए।
Yes, my lord, it should not come here.
मेंशन करके लगाया हूँ।
This is
रिकॉर्ड आ गया है। आ गया रिस्पॉन्ड नंबर 3 का वकालतनामा आ गया है
Appearance completed.
appearance complete है देखिए FA number 8 of 2023 from the records it appears that the appearance of the respondents is complete 1 2 सबने फाइल कर दिया वकालतनामा नोटिस हुआ है
For
कभी
3, my lord, it was rejected.
ये पता नहीं चल रहा है समी जी नोटिस ऑफिस नोटिस से नहीं बनाते इसमें खाली ऐसे लिखते हैं कौन कौन अपीयर हो गए हैं किसका अपीयरेंस पेंडिंग है सब कुछ नहीं लिखा हुआ है उसमें Office is directed to prepare appropriate office note in connection with appearance of the respondents in this case. Next week done. इसके बाद ही देखें खाली रिस्पॉन्ड नंबर 3 का दिख रहा है किसका सर्व हुआ नहीं हुआ भी नहीं सबको नोटिस गया था क्या
145 के लिए देगा
आने दीजिए उनका काम है ना कौन कौन अपीयर कर रहे हैं नहीं कर रहे हैं हो गया
Tata Steel is also a party, but
Item 25.
देखिए आज अभी तो नहीं बोल सकते ना दे आर नॉट अपीयरिंग
This is an application for substitution of legal heirs on behalf of representative of claim number 5, namely Bhagirath Singh, who died on 18th June 24.
देखिए आइए नंबर 1693 of 25 this interlocutory application has been filed for substitution of applicant number 5
Mentioned in para number 4.
who died on 18/6/2024 इनका वकालतनामा कहाँ है अपीलेंट नंबर 5 पे लीगल ईयर्स का वकालतनामा कहाँ है नहीं आप वकालतनामा फाइल करिए उनका वकालतनामा
Substitution हो जाएगा
जी नहीं आप पहले उनका वकालतनामा फाइल कर दीजिए
सभी लीगल से
सभी लीगल हम अलाउ करते हैं
आफ्टर सब्स्टिट्यूटिंग
ऐसी बात नहीं है क्योंकि अभी जो आप फाइल कर रहे हैं ना ये कौन एफिडेविट कर रहा है
नंबर 5
अपीलेंट नंबर 1 ठीक है और रिस्पोंडेंट कौन है रिस्पोंडेंट हैव अपीयर्ड स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट इसको कल रखें कोर्ट आवर्स के बाद इसको अलाउ करना ठीक नहीं है किसी के एब्सेंस में नहीं कर सकते
Item 26.